present, the panel is outside. One thing we need to address, the other half of the panel that I had them coming back at 2. It doesn't look like we're going to get to them today. When do y'all wish to have me tell the jury clerk when to have them come back?
Well, we're on number 7.
Judge, my suggestion would be to have them call in tonight, and we'll give them a time on the report, and if they're going to be back tomorrow. I'm certain that we'll get to them at some point tomorrow, but I hate to have them, I'm hopeful that we'll get to them at some point tomorrow, and I hate to have them waiting down there if we didn't need until 10:30 or 1:30 or whenever. So my state suggestion is have them call in tonight after 5.
That's fine for, that's fine, just at the end of the day, I know how many people we got through today.
Can you tell him to call back? Is that capable of doing it? Now, he also tells me there's several that have a problem with tomorrow, so I asked them to have those put them in writing what their issue is with tomorrow, and we'll let them know before 5 today, I guess. I don't know what they are, but okay, so if you'll flush them out, tell them to call back tonight. We'll have a message on there after 5 when they need to return. If they have an issue with it tomorrow, please have them put it in writing, their specific problem with their name and dirt. And then when they're done filling them out, bring them back up here. Okay?
So if we did want to report, we did have a contact with the juror, we were getting on the elevator, we allowed her to take the elevator out first, and we just waited for the next one.
Can we address that, because that's going to be a problem. There's no way for us to avoid getting on the elevator. The jurors are out there. Can we have counsel, the 15 of us or how many are here, go to the back and go out the back door?
I think that's a smart thing.
And then the question would be, how do we get in? Is there a way we can get in, somebody can let us in down there, and then we avoid this issue completely?
Or if you can contact them, let deputies know, let you in, that's fine. I'm going to let y'all worry about that.
Okay.
Now, there's one other person, Mr. Miller, Mr. Riles brought to my attention. I forget what he said. He had some kind of, where'd Riles? Have him come in just a second.
Is it Ronaldo Miller?
Yeah, I think so, Ronaldo. I think that's who it was.
37, 31.
You get Bob. All right, Mr. Miller, what was his situation?
He has either first aid or some kind of class for his work as a corrections officer.
Did he tell you what time it was?
He didn't give me a time, so
Is it today?
Yeah, he said it was today, yes.
Now y'all know what I know. I gather he's asking to be excused for this. Yeah, I guess.
He raised his hand earlier for cause.
State's position on Mr. Miller?
Well, I mean, there's issues that he had indicated previous that he is a corrections officer.
Discussed the case with a close friend, Morales.
We'll just go ahead and agree. The defense had previously requested to challenge him for cause. So we'll agree to that if they're still maintaining that.
Yeah, he was also one that raised his hand for the nature of his charges that he couldn't be sure.
Without objection, then, make sure I got the right. It's Ronaldo Miller in C31?
Yes, sir.
Okay. Why don't you just have him step in? I'll take him real quickly.
Sir, right up here, please.
He's okay right there.
Oh, okay.
Mr. Miller, I'm going to excuse you. They told me about your situation, so I'm going to go ahead and excuse you. I did want to thank you real quickly for filling out the application last week and coming in and letting us get a crack at you, but I'm going to go ahead and excuse you, okay?
Thank you, sir.
Yes, sir. Thank you very much.
Yes, sir.
Okay. Who did y'all want to have come in next?
Judge, you know what, I'm just going to sit here and let them take, since they have people they want to talk to, so whoever they want to, since that's the...
settled on that.
You're starting with the media.
Now, I want y'all to question on the individual here on the media exposure, if any, in the death penalty situation
Yes, sir.
only. Okay. Who would y'all like to call?
Okay, so my question is, I person had a media. That's fine, what he's talking about. I know the window. Gotcha. Rosa, do you have any questions for them? Judge, if we can bring in Rosa Bradford, number 7.
And Ms. Bradford?
Number 6.
Seat 6.
Seat 6.
Seat 6, yes.
Sorry. I'm looking at 2 different charts.
Number 6. Rosa Bradford. Rosa Bradford.
Eight.
7.
Ma'am, up here, please.
Bradford, thanks for bearing with us. I'm just going to have you have a seat right here where he's directing you.
Up here, please. Thank you very much.
Thanks for bearing with us. You're not in trouble or anything, you have anything wrong, don't worry. I'm just going to let them talk to you for just a few minutes outside the presence, see other folks, okay? Okay.
Thank you, Judge. Good morning.
Hi.
Well, I'm sorry, good afternoon.
Hi.
Your questionnaire reflects when we asked you regarding your opinions with respect to the death penalty that we call you a C, you won't know what that means, but what it means is you said it was appropriate in some cases and not appropriate in others, correct?
Right.
That's basically what the law says too, okay? The judge will give you a very detailed description of how a death penalty trial progresses, and that is the law. And all we want is a commitment from you that you will follow the law, the judge's instructions on the law. Will you do that?
Right, yeah.
Thank you. No questions. No further questions. They may have some questions.
Vince wished to inquire.
Yes, Judge. Ms. Bradford? Yes. Okay, do you understand that there are 2 phases to a first-degree premeditated murder trial? The trial.
I don't know a lot about it.
Okay.
Tell me.
Okay, so the trial that you're here for, there are 2 phases to it. Because of the nature of the charges, you were told that he's charged with first-degree premeditated murder
Right.
of a law enforcement officer, okay?
Okay.
And because of that charge, there are 2 phases to the trial. One we call the guilt phase, and the second one is the penalty phase.
Okay.
Okay? Now, if hypothetically we were to get to the second phase, which is the penalty phase,
Right.
that would be if the jury in hypothetical situations say, were to find Eriese Tisdale guilty of first-degree premeditated murder,
Right.
then we would go to what we call the second phase, which is the penalty phase. And that's where you, on your questionnaire, you wrote you were middle of the line, that you feel that it's appropriate for some cases and not appropriate for other cases.
Right.
Okay. On a scale of 1 to 10, where do you think you fall, starting with life without the possibility of parole as a 1, and death penalty as a 10, if, hypothetically, you were part of the jury
Right.
and you had already determined the guilt
Right.
of the accused, and then now you're sitting at the second the penalty phase, and you have the 2 options: life without the possibility of parole and the death penalty. Okay? Now you said, I'm middle of the road, you know, it's appropriate for some cases and not others.
Right.
Did you have any idea of what kind of cases you were thinking about that it's appropriate for?
Being a mom, I think more like children-based cases would be more appropriate. I mean,
Okay. Something involving killing of children.
right.
Okay. Any other that you would think that a death penalty would be something you would lean towards, that you would feel that that would be something you would lean towards?
I don't think so. I
Okay.
don't know. I mean, I've never obviously been in the situation. So.
Okay, so when I ask you on a scale of 1 to 10, with life being on the 1 end and death being on the higher end of 10, where do you think you are as far as the number?
I would be lower because based on my religious beliefs, I
Okay.
don't think that I should be purposefully, you know, being in charge of choosing the ending of a life.
Okay, okay, so with killing of children being some of the things that you feel very strongly about.
Right.
Okay. And you think you would be lower. Give us a number.
Like 2, 3?
2 for any other crime? So there's no other crime that you think would be warranted of the death penalty?
I don't think so.
Okay. Now, you mentioned the word based on your religious belief.
Right.
Okay. Now, the second phase, just
Right.
to tell you a little bit about it, you're comfortable sitting on the first phase, right? Deciding the law and the proof beyond a reasonable doubt.
Right.
Okay. So say we're in the second phase because the guilt's already been determined, and hypothetically you're sitting there, and in the penalty phase, it's a different standard, okay? But what happens is we talk about aggravators and mitigators, okay? And the aggravators are something that the state has the burden of proving to you beyond a reasonable doubt, okay? And then the defense gets up and they put on mitigators. And they only have to prove the mitigators to the greater weight of the evidence, which means that they get to show to you, present to you these mitigators, and you get to individually decide what weight you're going to place on those mitigators, okay? Now, at the end of the day, the law is that you are never required to recommend a death sentence, okay?
Right.
However, the law also states that you can basically chart it out and say, okay, hypothetically, go back to that, and we'll add another fact to the hypothetical.
Right.
Now we found him guilty, now we're in the penalty phase, and you're trying to decide where you're going with it, whether it's a life sentence recommendation or a death sentence recommendation. And the state, hypothetically, one of the aggravators is proven to you beyond a reasonable doubt, okay? The law is going to be given to you that says, if an aggravator is proven to you beyond a reasonable doubt, at least one, then you may choose the death penalty. Okay? Now, to offset those aggravators, if mitigators are proven to you by the greater weight, and those mitigators outweigh the aggravator that's presented and proven to you, then you must choose life. Okay? But at the end of the day, no matter if the state, hypothetically, has proven to you beyond a reasonable doubt the aggravator over the mitigators, you still can choose life. Okay? Is that a yes?
Yeah.
You're following me?
I'm following you.
Okay. So, even though, I understand your religious beliefs,
Right.
there's something that you're raised with, they're part of you.
Right.
But do you believe that you can sit on the second phase of this trial, if it were to go there,
Right.
and listen to both the mitigators and the aggravators to make that decision and make a recommendation by listening to both?
Yeah.
Okay.
Yes. So, I think this is why we talk to people, because there's nothing in your questionnaire that kind of indicated what your philosophy is based on. And you touched on it, it's religious-based. Tell me
Right.
what that is.
I was raised Catholic.
Okay?
And so, the way that I was raised was that I don't have the power of ending someone's life. Nor
Okay.
should anybody else. I don't want that power.
It's not the place for you to make that decision?
That decision, I don't judge. I don't want to be the judge of
Okay.
someone's life.
And, so obviously, the number one thing is the judge already told you, there's no right and wrong answers here.
Right.
There's only truthful answers.
Right.
All right? And, to say my religious beliefs are such and such that it could affect my ability to follow the instructions, there's nothing wrong with that.
Right.
But we can't read minds, so we need to hear it.
Yeah.
If that's where you're coming from. Do you feel that your closely held religious beliefs are, on this particular issue, are so strong that it could affect or impact your ability to follow the judge's instructions on the law as it relates to the death penalty?
The laws that relate to it, I guess no, but if I had an option of choosing like a life without parole or death, I would lean more towards life without parole, because I feel like that's not me to choose someone's death.
Okay.
Yeah.
Yeah, that's fine, I guess, but what I'm trying to drill down, in the end,
Right.
if you convict the defendant,
Right.
as Ms. Celdoni indicated, there's that second part of the trial.
Right.
And I have to prove to you aggravators. Now, you touched on one. You said children.
Right.
This doesn't involve a case of children.
No.
Are you saying that the only situation in which you could envision yourself voting for death would be if the victim was a child?
Maybe, yeah.
Okay, so are you unsure in your own mind with regard to your ability to vote for death under any other types of circumstances?
Yes, I think I wouldn't have the ability to think clearly if it wasn't a child situation. I think sensitive, and to me, it would touch me more if it was a child-based case. But since it's not, I think I would have more of me trying to settle with my own self and deciding the fate of someone else.
Okay, so that closely held personal religious belief, in your mind, would it have the potential to cause conflict with your ability to follow the judge's law?
It could.
Okay,
It could.
nothing for the judge.
Vince, anything further?
Yes, sir. Ms. Bradford, you said a few minutes ago when I was talking to you that you were open to listening to mitigating
Right.
factors and aggravating factors before you reached a recommendation.
Of course.
You understand that your role as part of the jurors, the jury, part of the jurors that we pick, is an advisory role,
Right.
that you're going to give a recommendation. And we are looking for people with diverse background
Right.
to make input and to make that recommendation as an individual recommendation.
Right.
As I said, the law is going to be instructed to you that you never have to choose.
Yeah.
However, you have to be open to listening to the mitigators and aggravators before you reach a recommendation individually to give to the court for sentencing if we get to that stage. Are you saying that you can follow those instructions?
Those instructions, yes. I can listen, I can give you my opinion, I can see, I fairly can listen and understand and take in what's being said,
Okay.
and my opinion on where it needs to go, yes.
Okay. All right, thank you.
But then the ultimate question, and I almost would feel more comfortable with the judge addressing this, but the ultimate question is, listening to everything, in the absence of it being a dead child case, could you vote for death? Or do you feel that you couldn't or you might have a problem with that because of your closely held religious beliefs? That's the issue.
Right, like, that's the thing, is I can listen and I can judge, and I'm not judge, but I can hear, and I think I can give my opinion and tell you what I feel, but I don't think that, in my personal opinion, I could vote the death penalty.
Right. I don't have anything further.
You all want to approach them? Bear with us just a minute, Ms. Bradford, okay? but I'm going to go ahead and release you. I want to thank you real quickly before I let you go for your service and bearing with us today. I know it's been a long day and filling out our forms last week, so I'm going to release you. You're free to go. Thank you, though, very much for bearing with us, okay?
Thank you.
Bradford was excused for cause over the case objection. Okay, state or defense wish to call another.
Ms. Roberts, Megan Roberts, Your Honor, is
Seat 7.
Ms. Roberts, up here, please. Coming right there.
Robert, thanks for bearing with us. You'll just have a seat right there where he's pointing to you. You're not in trouble. You haven't done anything wrong. Don't worry. Nobody's going to get on you. We just want to ask you some questions outside the presence of the other folks for a few minutes. But just make sure you speak up and just be as candid with us as you can, okay?
Good afternoon, Ms. Roberts.
Hi.
Okay, so just a couple quick questions. You had indicated on your questionnaire, have you read, seen, heard anything about the case? And you said yes, police officer was killed in line of duty. So the first thing what we're trying to figure out is what jurors know and how much of it they know. Sometimes what we find out is you're thinking about an entirely different case. So if you could for me now, if you could identify the source of this information and in as great a detail as possible, tell us what you remember reading, seeing, or hearing about the case.
It was the Tribune paper, and I read it a couple days after it came out, I guess 2 years ago. And then just all I remember is the name Sgt Morales, and I think there was a chase. I'm not 100% sure, and I just know he was killed in line of duty. And I saw it on the paper a couple days later, like the funeral procession, and that was it.
Okay, you say came out. What do you mean came out?
On the paper, in the paper. I just read it.
Oh, when it came out in the paper.
I'm sorry, that's all I read. I
Okay.
just read it on the paper.
So no details other than that?
No, sir.
Okay. So here's the rule. This is a court of law,
Right.
and therefore the laws rule. And the judge will tell you, if you're selected as a juror in this case, that your verdict must be based solely and exclusively on the testimony the state presents here in court. So I'll call a witness, they'll take a stand, they'll take an oath, you'll judge their credibility, and you'll try to figure out ultimately what happened in this case, but based upon the testimony and evidence in this courtroom. Do you understand that?
Yes, sir.
So my first question to you is, if that's the law, can you follow it?
Yes, I
Can you promise us that whatever you heard, read, or saw about the case over 2.5 years ago in the media will not be brought to bear on your view of the facts and the evidence in this courtroom?
Yes, sir.
Okay. Now, quickly to touch on the issue about the death penalty real quick, this is a potential death penalty case. Here, there is a law, a very specific law that applies to when the death penalty can and cannot be imposed, all right? You indicated on your questionnaire that it's appropriate in some cases, not appropriate in other cases.
Yes, sir.
That's like right in the middle. Okay. That's what the law says too. There's only one kind of case in the state of Florida for which the state can seek the death penalty, and that is first-degree murder. Okay? But not all first-degree murder cases even can you get the death penalty. Do you understand that?
Yes, sir.
So the judge will tell you, just because this is a first-degree murder case, or just because this involves the death of a law enforcement officer, doesn't automatically mean the defendant must get the death penalty. Do you get that?
Yes, sir.
Can you follow that?
Yes, sir.
Okay, so what will happen is if you as a collective member of the jury find the defendant guilty of these offenses, we have a second trial. Don't get scared. It's all worked into our time frame here. But it's a kind of we call it the penalty phase of the trial. And during that phase of the trial, the judge will tell you, before you can vote for death, you must find that the state has proven an aggravator beyond a reasonable doubt. For instance, an aggravator at law is the defendant murdered a child. That doesn't apply here, obviously, right? If you find beyond a reasonable doubt that the defendant murdered a child, you can consider voting for death, but you don't have to vote for death, okay? The law says what you need to do is weigh it. How weighty is that? How important is that in my mind? then the defense has the right to put on evidence of mitigation. For instance, evidence of mitigation could be something like the defendant suffers from a serious mental disorder or something like that. Okay? And if you find that to be very weighty and outweigh that aggravating factor, or I know you're not a law student. Good. The law says if that mitigating circumstance or circumstances outweigh the aggravator, you must vote for life. Could you do that?
Yes.
However, if that aggravator outweighs any mitigators and you think it warrants the death penalty, could you vote for death? Okay. That's the law. Can you follow the judge's instructions on the law as it relates to that particular phase of the trial?
Yes, sir.
Okay, thank you. They may have some additional questions.
I'm Charles. Okay, I know that the last time, or you said that you read about it in the Tribune a couple of years ago. I know that the judge told everybody, said, listen, don't try to avoid it on the media, try to not read the newspaper, try to not watch it on the news. Have you seen something and had to kind of look away?
No, sir.
No?
I've avoided all news and everything at all possible.
Okay, good. Have you had to walk away from anybody else talking about the case?
No, sir.
So you haven't had other jurors or just other family members or friends talking about it and you had to walk away?
No.
No? Okay, good. So tell me a little bit about what, you said that, and I tried to take notes, you said that you saw it in the Tribune a couple of years ago, you said that you remembered his name. Why did you remember his name?
Just not really often. I think the last officer that was killed in Port St. Lucie was, I think, 9 or 10 years ago, and then I remember his name as well, so it just kind of stuck out to me, I guess.
What was his name?
Gary Donald, I believe.
And how did that make you feel when you first heard about this?
It hurt. But, I didn't know, I don't remember all the facts and everything, so I was trying to remain unbiased as possible.
Of course, we appreciate that. So the other couple of notes that I wrote down, you said maybe you kind of remember something maybe about a chase, but then you remembered the funeral procession as well, right?
I just remember seeing a picture of it on the front of the paper and that was all.
Okay, so you didn't go to the funeral?
No, not at all. No, I just remember seeing like the casket or like the hearse, I guess, on the front of the paper, and that was all I remembered.
Did you know anybody that did go to it?
No, I don't.
Okay. Now, I saw on your, this is why we have the questionnaires,
Yeah.
to learn a little bit about you. But you had written down that your mom was a law enforcement officer as well, right?
She retired. She was in West Palm.
Okay. And which agency was she with?
The West Palm Police Department.
Okay, so not the Palm Beach County Sheriff's Office, West
No.
Palm Beach PD?
Yeah.
Okay. How long was she with them?
10 years.
And what type of
Just a patrolman.
patrolman? So she was actually, like, she wasn't like a plainclothes detective. She was
No, just a regular, not regular officer, but I guess just,
dressed in blue, had the star on her chest.
Well, she didn't have a star, she had just a badge, but.
Oh, the badge. Okay.
Yeah, sorry.
So that's what I thought it was a star, kind of. Oh, whatever. But she had the badge, the more like oval shaped thing, right? Okay. So would she dress basically just like these guys, right? Full uniform, everything like that. And what type of vehicle did she drive?
Squad car, regular squad car.
So it had West Palm Beach PD written across the side of it. It had a,
Can we approach a minute?
Yes, sir.
come back to some of what we were just talking about later on, okay? But what I'm kind of cutting to the chase, what I'm trying to figure out from you is how did you really feel when, I know you said that this was upsetting, and you remember the name of this cop, Sgt Morales, as well as the other officer that died about 10 years ago, and is some cases wind up hitting a little too close to home.
Mhm.
And what I'm trying to figure out from you is if, because of the nature of this case, is this a little bit too close to home for you?
It's not. I mean, my mom was a cop, and I have the ultimate respect for law enforcement, but, I mean, I was given the task of being a juror. It's my job, and it's my duty to remain unbiased in all of this. And to me, that's more important than putting my feelings aside and seeking, the truth in all of it and what I really feel happened, and not just my opinion, and not letting my, I guess, things that could be close to home, not letting that get in the way of what really happened, and being fair in all of it.
Okay. All right. Well, we kind of have to split parts of the jury selection up, so I'm not going to delve a lot more into what we were just kind of talking about right now, but I just want to talk to you just about the media exposure and really what you knew about it. So Ms. Saldonio is going to have some questions for you about the death penalty and just kind of your thoughts and feelings about that as well, okay? It was nice to talk to you.
Thank you. Hi, Ms. Roberts. Hi. I'm going to ask you a few questions in reference to the death penalty. Because as Mr. Bagnall said to you, that there's going to be potentially, he called it 2 trials, I call it 2 phases of the trial, if we get to that second phase, which is the penalty phase. One of the things you need to know if you are chosen to sit on this jury is that if, hypothetically, you get to the second phase, the only way you get to the second phase is if you sit on the first phase and you make a decision that the state has proven beyond a reasonable doubt that the person is guilty of first-degree murder, okay? So hypothetically, we've done that. The jury's come back and found him guilty, okay? Now we're in the second phase. Now your questionnaire, you put right in the middle that you believe that the death penalty is appropriate in some cases and not in others.
Mm-hmm.
Can you give me some examples of what kind of cases you think the death penalty is appropriate for?
I guess just speaking out, I guess to actually tell someone, like, having their head, like, I'm going to actually kill this person, I guess, it wasn't like on the spot, but, I'm premeditating that I'm going to actually go out and, you're planning to kill someone. I believe that. I mean, you're planning, you're going out of your way, and it wasn't self-defense, it wasn't, an accident, you're actually planning in your head, you're planning, you thought out this process, just, you're going to go and kill someone or hurt somebody.
Okay. Breathe. I have the same issue too. Sometimes we have to breathe. Well, the little issue that I have with that is my hypothetical I gave you was the first part of the trial, you as a juror, the rest of the jury members, have already found that. They found that premeditated issue.
Okay.
They've decided that this was a premeditated murder. Okay, because that's the only reason why you would get to the second phase.
Okay.
So you've already made that determination, and now when I asked you to give me an example of somebody that you think would be appropriate for the death penalty, you used the word that you've already made that decision. So, that being said, are you saying that if guilt is found premeditated in a hypothetical case, would you be leaning towards the death penalty? Okay. Now, are there any situations where you feel that a life sentence would be appropriate? I know you mentioned self-defense.
If it was self-defense, or like, let's say there's like a mental issue involved, or like a physical handicap or something like that, I mean, I would definitely take all of that into consideration, but if it's been proven that, there was no mental or physical handicaps or anything like that, and it was, and they were very sane and of a clear mind, then I would go for the death penalty.
Okay. So, when you said you're middle of the line, that you would go death penalty for some cases and not death penalty for life for some cases, you believe that if premeditated murder is proven to you without any, what you say, explanation that you feel is appropriate, that death penalty would be an appropriate choice for you. Right? And you would lean more towards that than life. Okay. Do you feel that you would be the type of person that could listen to aggravators and mitigators in the second phase before you make your recommendation? Okay. But based on the hypothetical that I just told you, you think that you would lean more towards the death penalty if the mitigators don't outweigh the aggravators?
Yeah, I mean, it all depends on what is presented at the time, and, I don't know any facts, I mean, what's going on, but it all depends on what's presented at the time, because it's not something lightly to put someone's life on the line, to take their life. It's not something I would play with them lightly, I guess.
Okay, of course. Now, is there a circumstance you can think of that you would think, besides mental health or just self-defense, I think that's the example you used, that you would think that maybe you would consider a life sentence?
It was a car accident and maybe resulted in someone dying. I mean, I still believe it was, it was an accident. It wasn't done on purpose, but I mean, you still have to get paid for it, I guess, in a way. I'm not sure if that's the right way to say it or not.
Okay. Yeah, no, I understand exactly what you're saying. So if the law is presented to you and the law says, your instruction on the law that an aggravator is proven, and that it's proven to you beyond a reasonable doubt, and mitigators are presented to you, but they're not mitigators that you feel weigh enough. The law and the law says that you never have to choose death.
Right.
That if an aggravator is proven beyond a reasonable doubt, you may choose death, which is what you said. If they prove an aggravator and you don't give much weight to the mitigators, then you're going to choose death, right?
And you need to say yes or no, please, so it's
I'm
clear.
sorry. I'm sorry, Ryan. But if they don't prove an aggravator, then, and it's just mitigators, then you must choose life. Okay. So if the mitigators are there and the aggravator is not, you're saying you'll be able to choose life?
Yeah.
Okay. But at the end of the day, you still believe that if it's not something that's proven to you as a mitigator and you give great weight to it, then you feel the death penalty is the appropriate sentence?
Yeah.
You understand the charges before us are law enforcement, and based on the nature of law enforcement, do you think that in and of itself is a reason for the death penalty?
I don't.
Well, I mean, it's something that is, part of your upbringing, obviously.
Yeah.
And I know you're kind of, looking at you, this is a little bit tough for you to talk about. So when we
Yeah.
talk about the death penalty, I just mentioned because the charges are with a law enforcement officer.
Right.
Is it, are we at a disadvantage? Because right now, you can't walk in here and your makeup is who you are. When you go to choose and you make a recommendation for the death penalty, are you tending to lean more towards death penalty based on the fact that it's a law enforcement officer? You're not?
No.
So you still feel, even though you appear to be a little emotionally upset about the whole topic.
Just nervous and sorry.
Oh, okay, that's okay. I understand that. That you can still listen to both sides.
Yes, like I said, I mean, it was law enforcement, and law enforcement is close to me, but I've been given a task and a job to remain unbiased in all this, and that's something that I'm going to do.
And your opinion individually is very important to us when we make a decision whether or not this is the kind of case for you to sit on. We just want to make sure that we're not on the sliding scale of your decision-making based on your own personal
I understand.
feelings. So we appreciate you being honest with us. And I'll leave you alone after this last question. Do you believe that you can listen to the aggravators and mitigators if you were to go to the second phase and give Eriese Tisdale a fair shot at making a recommendation? Or
Yes.
you're already predisposed based on your upbringing?
No, I'm not very sorry. I believe I think of a fair session.
Recommendation?
Yes.
Okay, thank you.
Back at all, anything else?
I don't have any further questions, Judge.
Do you want to approach or no?
No?
No.
Ms. Roberts, I'm going to excuse you for today. I'm going to give you a number to call
Yes, sir.
after 5 p.m. tonight. And there'll be a message on there, what you need to do, if anything, as far as jury service. I'll write it down here for you. She's going to give it to you with this number on it. If you just call after 5 p.m., there'll be some instructions on it.
Judge, isn't it Thursday night?
Did I say tonight? I meant Thursday night. Thursday night, I'm sorry, not tonight, Thursday. Thursday night. Okay, and the number's on here. Okay, thank you very much, ma'am. All right, who would y'all like next?
He's already calling for him, Judge.
Solo, Stein, Lee. Sir, up here, please.
Mr. Stein, thanks for bearing with us. We'll come right up there on the front row where he
Come
showed
in
you.
here and take a seat up there, please. Thank you very much.
Thanks for bearing with us, sir. You're not in trouble or anything. You haven't done anything wrong. Don't worry. Nobody's going to get on you. They just wanted to ask you a few questions outside the presence of the other folks. So if you can just make sure you speak up and be as candid with us as you can. Okay?
Good afternoon, sir. So one of the first reasons we brought you in is because you had indicated on your questionnaire that it's possible you may have read, seen, or heard something about the case, okay?
Yes.
And what we're going to do is probe that a little bit in just a moment, but I want to kind of get a couple of basic concepts out with you before we start. Obviously, we're in a courtroom,
Yes.
a court of law, correct?
Yes.
And so, by definition, the law controls in this process, right?
Yes.
Okay. One of the basic premise of our criminal justice system is that the defendant is to be presumed innocent by all prospective jurors. You heard that before?
Yes.
Okay, and that because Mr. Eisenhower, on behalf of the state, charged him with a crime, it's our job to prove that he did it. You get that?
I do.
You understand that?
Yes.
And you accept that?
Yes.
Okay. Now, with those two basic ideas in mind, let's talk about what you know. To the best of your ability, tell us in as much detail as possible what you recall reading, seeing, or hearing about this case outside the courtroom.
Well, 2 years ago, this happened. Am I speaking loud enough?
I can hear you
Yes, sir.
fine.
You're good.
All right. 2 years ago, this happened. And I remember when I was in class, I was taking a criminal justice class, and one of the instructors of Gary Morales
Right.
came to class to speak about well, mostly narcotics in university, but she did imply that she was, well, not imply, but she did say she was the instructor of Gary Morales.
Okay. And did she talk to you about what happened during his murder, or did she just say, I instructed him at some point in time?
From what I remember, she mentioned that, yeah, that she instructed him.
Okay.
And that's what I remember
All right.
about it.
All right, so you don't have any information about what actually transpired during the course of the crime?
I have some knowledge that Gary Morales was shot
Okay.
by Eriese Tisdale,
Okay.
and that's what I do remember, yes.
Tell us, be specific, be specific if you can as to what information you think you have and where you got it from.
About 2 years ago, it was on the news
Okay?
that he was shot.
Okay.
And that's all I remember was 2 years ago. It's kind of vague, so.
Okay.
But I know it was big news about 2 years ago, and people were talking about it in class, outside class.
Okay. Now, in your questionnaire, you indicated that as a result of anything you learned, read, heard, or whatever, you formed no fixed or definite opinions regarding the defendant's guilt or innocence. Is that correct?
Yes, think so.
Okay.
From what I understand, yes.
All right, so when we go back to me telling you that it's our job to prove it, and you've got some criminal law background, I guess, right?
Yes, I'm also a paralegal studies student at IRSC,
Okay.
so.
Okay. So it's our job to prove the defendant's guilt beyond a reasonable doubt, right?
Yes.
One thing the judge will tell you is your verdict in this case can only be based on the evidence and testimony you hear here in this courtroom.
Right.
You with me?
I hear you.
Okay, that's the law.
Yes.
All right, and you're sworn to uphold the law if you're selected as a juror in this case, okay?
Yes.
If yours...
Objection, Your Honor. Can we approach?
Yes.
Okay, so we have those two basic concepts, right? The presumption of innocence and the burden of proof, correct?
Yes, sir.
And the only evidence you can render a verdict on in this case is based upon the evidence you hear here in court, correct?
Yes, sir.
So my question to you is very simply, can you assure us that you will follow the judge's instructions on the law as it relates to the presumption of innocence and the burden of proof, and not allow what you learned 2 years ago from the newspaper or a classroom to affect your verdict in this case?
I'll try my best, yes.
Okay, so now the mistake you made was giving an answer that gets lawyers probing further. You say, I'll try my best, and that's an honest answer, because what I'm asking you to do is kind of engage in some mental gymnastics, right?
I'm just being honest.
I got you.
All right.
Here's the deal. Let me see if I can put it in black and white for you. You're sitting as a juror in this case.
Yes.
A witness says the car was pink. And you say, wow, you just have a full total recall of something you read in the paper, and you remember reading in the paper that the car was black. Okay? The law says you can't allow what you read in the paper to affect your finding regarding the color of the car. The only evidence is that the car was pink. Can you leave that information outside using that type of a hypothetical and make a conclusion based upon the witness's testimony that the car was pink?
If I do know, I mean, that's a fact, because, I mean, sometimes conflicts, you get what I mean?
Mm-hmm. Right, you mean if there's conflicting testimony in the case?
I may learn the wrong information in the court, but what I learn outside might be true.
Okay.
And I'm not too sure.
All right, so you have a question in your own mind that you cannot set aside what you might have learned outside the courtroom?
I think so. I think I get what you're trying to say.
Right, but I'm glad, I understand, but you think you might have a problem setting aside what you learned outside the courtroom, is that what you're saying?
I might have, yes.
Okay, that's all. I appreciate it. Thank you for your honesty.
Defense wish to.
No objection. Mr. Stein, I'm going to release you from service on this case. I appreciate you bearing with us. I thank you for doing your civic duty with us and your cooperation today. But I'm going to go ahead and release you. You don't have to come back unless you want to.
All right.
Okay, you understand?
Can I ask a question?
Yes, sir.
So you're saying I'm being released?
Yes, sir.
So I don't have to return tomorrow?
No, sir. Not unless you want to.
Not unless I
You can come watch, yes, sir. No, you don't have to come tomorrow, no.
Do I just leave right now, or what?
You can if you wish. If you want to stay and watch, you're welcome to do that. I can't run you out of here, but you don't have to stay unless you want to.
All right, thank you.
Okay? Okay.
So like outside, I won't be like arrested or anything?
No, sir. Well, not by us anyway, no. No, you're free to go. Thank you.
Thank you.
You too.
Mr. Foster, up here, please. Sir, can you take a seat right here, please? Thank you very much.
Mr. Foster, thanks for bearing with us. If you're not in trouble or anything, nobody's going to yell at you, have anything wrong. I just want to ask you a few questions outside the presence of the other folks. So if you can just make sure you speak up and be as candid with us as you can, okay?
Good afternoon, Mr. Foster. How you doing? I'm doing good. Thank you for your patience. You had indicated during the judge's initial questioning that there might be, I don't remember exactly how he put it, but something about the nature of the case that might affect your ability to serve as a juror. You remember what I'm talking about?
Correct.
Go ahead and tell us about that.
Just due to my profession,
Okay,
I am in law enforcement myself.
okay,
I've been with the Department of Corrections going on 10 years.
right,
Served the Rapid Response Team for 8, and I'm now serving K-9
okay. And all that time with the Department of Corrections?
all that time.
Okay, and so I guess just to put it very plainly, do you feel that based upon your career, we kind of have a leg up? That is, you would not be able to set that aside and judge the case based upon the facts and the evidence?
Correct.
Because it involves a law enforcement officer?
Correct.
Okay, all right. I don't have any further questions.
Vince, Christine Clark.
No objection.
State, Vince is moving across channel, state doesn't have any objection. Mr. Foster, I'm going to let you go. Thank you very much for bearing with us. I appreciate your patience with us.
Thank you.
And let us get a crack at you. But thank you. You're free to go. You don't have to stay unless you want to.
Thank
Okay?
you.
All right, who do y'all wish to call next? Mr. Foster, be excused for cause without objection by the state.
Raymond, you already got it?
Sir, up here, please. Come right over here. And take your seat right here. Thank you, sir.
Raymond, thanks for bearing with us. You just have a seat right there. You're not in trouble or anything. You haven't done anything wrong. I just want to talk to you outside the presence of the other folks for just a few minutes. So if you can just make sure you speak up and be as candid with us as you can, okay?
Okay.
Mr. Raymond, good afternoon, sir.
Good afternoon, sir.
So you indicated during the course of the initial questioning from the judge that there was something about the nature of the case that could prevent you from being fair and impartial. Do you remember that?
Yes.
Tell me about that, please.
Okay. The church I go to, my pastor work with the deceased
Sgt Morales?
Sgt Morales.
Okay.
And he's the one that baptized him, and he visited the church a couple times. Okay, last time was on August 2nd.
At your church?
Yes.
Okay. And are you telling us that it's because of that association with the church that it could cause you difficulties in being a fair and impartial juror?
Yes.
Okay. All right. That's what we needed to know, and I appreciate that.
Vince, wish to inquire.
No objection.
Mr. Raymond, I'm going to go ahead and release you from jury service. I appreciate your patience with us and your attention, and thank you for doing your civic duty with us. You're free to go if you wish. You're, of course, welcome to stay if you wish, but we'll let you go.
All right, thank you.
Yes, sir. Thank you. Who would y'all like next?
Seat number 11 in Juror. Thank you.
I'll be seat number 11. I am Varick, seat 11. Okay. Judge, you must have stepped out to the restroom, Deputy Wallace said.
Y'all want to, somebody else, we'll get back to him.
Sure. If we could, seat 12, Ms. Butler.
Yes,
Ms. Butler, come in, please.
yes, Bobby. Jacqueline Butler, seat 12. Butler up here, please. Take a seat right here, please.
Thank you, Ms. Butler, for bearing with us. You can have a seat right there, ma'am. You're not in trouble. You haven't done anything wrong. Don't worry. We wanted to talk to you outside the presence of the other folks for just a few minutes. So if you can just make sure you speak up for us and be as candid with us as you can, okay?
Okay.
Good afternoon, Ms. Butler.
Hi.
So we brought you in here because of a couple of answers that you provided on your questionnaire. I want to start off by talking about a couple of basic concepts of law and how those relate to some of the responses you gave on the questionnaire, okay?
Okay.
There are two basic premises to the American criminal justice system. The first is the presumption of innocence. Have you heard of that?
Yeah.
Okay. And the second is the burden of proof. And that means when your government accuses one of your fellow citizens of a crime, it's your government's job and burden to prove his guilt beyond a reasonable doubt, okay?
Right.
All right. And the way we do that is through offering testimony in an open courtroom like this. And then you make a decision based upon what you hear in court, all right?
Okay.
All right. With those two things aside for a moment, let's talk about your answers to the questions that relate to having read, seen, or heard something about this case. You remember that?
Yeah.
Tell me in as much detail as you possibly can muster up what it is you remember reading, seeing, or hearing about this case.
Back some time ago.
Yep.
I remember seeing it on the news and seeing some small children involved who lost their father.
Okay.
Hearing that he was shot and killed, sitting in his car, feeling bad for the family.
Okay.
Then pretty much it went away. I think there was a fundraiser or something, I remember. And then the morning that I had to come here, last Tuesday, I'm laying in bed and I've got the news on, you know, just checking the weather, channel 5 at 5 in the morning. And I said, okay, I can sleep in because I go to work at 6 in the morning. I can sleep in because I don't have to be there till 7:30. And then I heard, and there's all these jurors coming in. I says, well, I don't even know exactly where I'm going. And then they explained what the jurors were coming for this case here. And I said, if there's that many people coming, I better get in my car and find a parking space because I didn't know exactly where I was going. But that was that morning.
Right.
And what they ever said on the news was, you know, the person who was accused of killing the police officer.
Okay.
So that's when I said, oh, I must be part of that.
All right. So as a result of this, what you saw back a couple of years ago and then kind of your refresher course the morning of
Yes.
jury selection, did you form any fixed or definite opinions regarding the guilt or innocence of anybody in this case?
I don't want to say yes and I don't want to say no.
Okay.
It was from years ago. It was that this person was caught,
Mm-hmm.
and you know how the media makes it. So
It's a done deal,
not necessarily.
right?
My husband is a felon, and he was going through a small town in North Florida, and when the sun is coming right in your eyes,
Mm-hmm.
and he wasn't familiar with the road, and he ran a stop sign. At the same time, another car was going through, and some people died because he hit them. So the media made it, I wasn't around, but I've seen things since then that he had. The media made it sound like he was just the worst person in the whole wide world, when in fact it was the sun in his eyes in an unfamiliar area, and that's what happened.
Okay, so that's a great analogy for us to start off our conversation here, but the point it being, would you agree with me that on occasion the media gets it wrong?
Yes.
Okay, so would you also agree it would be a very bad idea to rely on what you heard or saw outside the courtroom in returning a verdict here in the courtroom?
I agree with you.
Now guess what? The law says you can't do that. That's what the law says. If you're going to serve in this case, your verdict has to be based upon the evidence and the testimony that happens here in this courtroom, okay?
I understand.
All right, so the fact that you know something about the case or the fact that you may have expressed certain opinions about the case doesn't disqualify you. What we need to know is, can you follow the law? That is, can you return a verdict if you're selected as a juror in this case? Can you return a verdict based only upon what happens here in this courtroom?
I think I can, because
Okay.
of the fact of what I've seen in a
Sure.
personal.
Right.
You know, you hear something, and from
Right.
years ago.
So the problem with I think I can is lawyers keep coming at you. And I know that it's tough because we're asking you to like, how am I going to react under a certain circumstance?
Right.
But just assume hypothetically that you hear a piece of evidence here in court that's different with what you remember reading years ago. Can you promise us you'll consider only what you hear here in court?
Yes.
Okay. Now, let's talk about the death penalty for a minute.
Okay.
Okay? You indicated on your questionnaire that you believe in an eye for an eye.
Yes.
Right? Okay. And that's fine. And those are your opinions. And you're entitled to those opinions as well, correct?
Yes.
The issue again for us here today is, can you follow the law? And I'm going to explain to you how the law works in a death penalty case.
Okay.
All right? You stop me if I get too confusing.
Okay.
In the state of Florida, there's only one crime that is even potentially subject to the death penalty, and that's first-degree murder, okay?
Okay.
So the incident you talked about, the car accident where somebody dies, can't get the death penalty for that. Can't get the death penalty for a second-degree murder. Can't get the death penalty for third-degree murder. Only first-degree murder, okay? So there's two parts to this trial. There's the first part of the trial, the first phase, and the second part, the second phase. In the first phase, your whole job is to do what I just talked about. Did he do it? Did they prove he did it based on the evidence, okay?
Yes.
If you find the defendant guilty of first-degree murder, then and only then can you consider what the appropriate penalty would be, okay?
I have a question.
All right.
Okay. First degree murder
Mm-hmm.
as compared to second degree murder. What
Right.
is the...
First-degree murder in the context of this case is premeditated murder. Second-degree murder would be, let's say you got a guy you don't like, and you go by his house, and you see the lights on, and you decide, well, I'm going to show him, I'm going to shoot a bullet through the front window. I don't want to kill anybody, but I'm just going to throw a bullet through the front window to scare him. And you shoot and kill somebody in that house. Okay?
Okay,
That's
okay.
probably going to be second degree. Maybe somebody could argue it's not, but that's okay?
Okay.
That's the best I can do.
Okay.
All
I
right.
just didn't know what...
That guy don't get the death penalty by law. It doesn't matter whether you think eye for an eye or a tooth for a tooth. Are you with me?
I got you.
Okay. So now, you have determined the defendant committed first-degree murder. We go to the second phase. You cannot automatically go into the jury room and vote for death just because you think eye for an eye or it might be an appropriate sentence. Do you understand that?
Yes.
Because that's what the judge is going to tell you the law is. Okay?
All right.
Can you follow that?
Yeah.
Okay, that's fine. And again, it's about putting your opinions aside and doing what?
Right thing, following
Follow the
following
law.
what I've heard
That's right.
here, and following the law.
That's it. That's all you have to do is commit to follow the law. Then, what the judge will say, before you can consider voting to impose the death penalty, the state has to prove the existence of at least one, what we call an aggravating circumstance. So your next question is, what's an aggravating circumstance?
Right.
I'll use one that doesn't apply.
Okay.
Hypothetically, an aggravating circumstance at law is killing a child under 12. That would make a first-degree murder case potentially worthy of the death penalty, okay?
Yeah.
So, in that case, if you determine that we proved that the victim of the murder was a child under 12 years of age, you could vote for the death penalty. But you don't have to, okay?
All right.
What you have to do is you have to look at that aggravated and you have to do what we call weighing it. And what that means is you're looking at it, you're saying, does this make the murder so much worse that in this case it warrants the death penalty, okay? And if you say it does, then you can vote for death, all right?
Mm-hmm.
Are you with me?
I got you.
All right, you stop me if I lose you.
All right.
All right, so we've passed that now. Now you've got an aggravator. You're saying it's a weighty enough aggravator, in my personal opinion, based on all the evidence, that I could pose the death penalty. But we're not done. Because what you need to do next is you need to look at the mitigating circumstances, okay? Those are going to be things, they can be just about anything, the defendant's background. Here's a good one that doesn't apply in this case. The defendant was an accomplice to the murder. That is, the defendant is not the one who actually killed the victim.
Okay.
That can be a mitigator. Now, if you look at that mitigator and you say, you know what, he's not the actual killer, I think that's very weighty, and it outweighs the fact
Right, okay.
the law says you have to vote for life. That's the law. Can you follow that?
I can.
Can you follow, if at the end of this process, you've determined that the mitigators outweigh the aggravators, and the law says you must vote for life, can you follow the judge's instructions on the law?
Yes.
Okay, the judge is going to give you the rules to this process. Can you promise us you'll follow them?
Yes.
Okay, thank you.
Hang on one second.
Hi.
Hi.
Okay, I'm going to ask you some questions about some of the kind of media exposure that you have with this case, okay?
Mm-hmm.
So, I tried to take notes when Mr. Backett was talking to you, that way we're all in the same room. So, you said that you did see some initial media reports about this a couple of years ago. Was that on TV? Was that in the newspaper? Do you read it online?
I don't go online for
Okay.
pretty much anything. I don't really read the newspaper, but when I get up in the morning, I always turn the news on. And that's, what I've heard
Okay. And
on TV.
right. And this case got quite a bit of exposure. I mean, we even have a camera in the courtroom looking at us right now. So, how many stories do you think that you actually watched about it?
I don't know. Like I said, I get up in the morning, I turn on the news. I didn't hear a whole lot because, it just gets old. And really, I just watch the weather myself. So, but when it's on and it's in the back, you're in the bathroom, the TV is on, you can hear what's going on. I don't know how much I've heard, really.
Sure. When you first started hearing about it, was it back when this happened?
Yeah, because when it first happened, it was all over. It
Right.
was, like you said, it was pretty much the topic of conversation on the news.
Mm-hmm.
And that was about it.
What are some of the things that you thought about when you first heard the story?
I feel bad for the family. I lost a sister in a car accident, and I remember how losing someone, the people that loved that person, how it hurts.
Mm-hmm.
You're not going to see them again. You're not going to, you can be together one afternoon and the next day they're not there. And it hurts, it hurts you in your heart.
Mm-hmm. Did you wind up seeing the news stories with Sgt Morales' family?
I think I remember seeing something about a fundraiser going on or something like that for his family.
Did you wind up going to the fundraiser?
Oh, no.
Okay, but you heard about fundraiser for his family through the media.
I think I did. I think that's where I heard about it. If I remember correctly. I mean, that was a while ago, and it's kind of vague, but I think I remember something like that. You asked me to
Oh yeah.
tell you what I kind of remember, and that's what that was about it.
Okay.
And then again, last Tuesday morning.
Right, the other morning when you were getting
Yeah.
ready to come to court. I'll come back to that in a second. But so back when this originally happened, and you said that you were watching stuff on the news about it, did you learn about the actual crime itself, other than just a police officer was killed?
A police officer was shot, and that's what I remember.
Mm-hmm.
And I remember something, and I don't even know if this is, if he was shot while he was in his patrol car, but that's about it. And that someone was arrested. And that's about all I remember.
Okay. Because one of the questions on your questionnaire said, as a result of anything you've seen, heard, read, discussed in this case, have you formed any opinion as to the guilt or innocence of the accused in this case, Eriese Tisdale? And you checked off the box yes, and you wrote Sgt Morales was shot to death.
Well, he was shot. Now, the words you use, aggravated or
Right,
whatever.
aggravators and mitigators?
Yeah, that I have to learn more about. I mean, I don't,
Mm-hmm.
that's, I didn't check that off, but from what was explained to me, I have to do what's presented,
Sure.
That's all I can say.
And I don't want to put words in your mouth, but is it fair to say that you've already made a decision about guilt?
Not after I've been explained all the different things. I got a new knowledge on everything today.
So,
Could I be more open-minded than what I'm saying, yes, he's guilty? Yes, I can be.
okay, so, again, correct me if I'm wrong, because I'm just trying to make sure that I'm understanding we're on the same page. Is it that you believe that Mr. Tisdale was guilty before you came in here today, and then after Mr. Backetall gave you this lesson in law that you've changed your mind about?
No, I feel that he is guilty, but I don't know how guilty he is. If
Meaning whether he deserves the death penalty or not?
Yeah, I believe that it happened and that he did it, but I don't know any more than that.
Okay, so, and again, let me know if I'm twisting your words, but you believe that coming in here today, and even after talking to Mr. Backetall, you do believe that Mr. Tisdale is guilty of murdering Sgt Morales, but since you haven't heard the aggravators and the mitigators, you don't know whether or not it would be appropriate for a life sentence or a death penalty sentence. Is that?
Pretty much. I still, I don't know how to explain it. I feel that he did it, but I don't know any more than that. So that would be guilty. Unless it was proven differently to me.
Okay, so guilty unless it was proven differently.
Yes.
Okay. Just one moment, please.
That's fine, no objection.
Okay.
Why don't you just prove it?
Yeah.
If you want to go over.
For cause, Your Honor.
Ms. Butler, we're going to go ahead and release you, ma'am, from jury service. I want to thank you before you go for your service and bearing with us. I know it's been a long day for you. Thank you. You're free to go. Watch your step there, please.
All right. Bye-bye.
All right, thank you, ma'am.
We're going to the individual that was...
It was seat 11, Vera? I don't know how to say it.
Excuse me, Judge. Again, Deputy Juror says he has not been back. You don't think he came back from lunch?
Okay, well, we'll have to worry about it later. Y'all wish to call another person?
Yes, sir. Please move on to Miss Aranda in T13.
Irene Aranda.
C13, Irene Aranda. Ma'am, up here, please. On this first row here. And take a seat right there. Thank you very much.
Rhonda, thanks for bearing with us. You're not in trouble or anything. You haven't done anything wrong, don't worry. I'm going to let them talk to you a little bit outside the presence of the other folks. And just make sure you speak up for us and just be as candid with us as you can. Okay? Thanks very much, Mr.
Good
Patty.
afternoon,
So,
Ms. Aranda, right?
yes.
Okay, so the point of this exercise is basically to get a commitment from our prospective jurors that they will follow the judge's instructions on the law, okay?
Okay.
So what we're going to do is we're going to talk a little bit about some of the laws that will apply, and then we're going to talk about a couple of answers you gave in your questionnaire, all right?
Okay.
All right. So the first very basic premise of criminal justice system is the presumption of innocence. Do you understand that? Have you
Yeah.
heard that?
Yeah.
So as the defendant sits here today, the law requires you to presume him to be innocent. Doesn't mean he's innocent. It means you must start off with the presumption that he is. Are you with me?
Yeah.
And then it says, number two, when the government accuses one of your fellow citizens of a crime, they got to prove it beyond and to the exclusion of a reasonable doubt, okay?
Yeah.
And we can only do that by calling witnesses and offering testimony and evidence here in this courtroom, right?
Yeah.
Okay. Now, let's talk about what you put in your questionnaire. You said that you may have read, seen, or heard something about this case in the media, right?
Right.
As best as you can, tell us in as much detail what it is you recall reading, seeing, or hearing, and where you got that from.
Most of it was like Facebook posts that people were posting his pictures and a local officer was killed. But basically that's what I read on Facebook, and then on the local news, on Channel 25 as well, just basically just reading about the report. But I never really looked into it more.
Okay, I don't understand how Facebook works in this context. How would somebody
So say someone posted a Facebook post like on a local officer was shot, and they put his picture and basically who it was, and it would happen in Fort Pierce. That's how.
Okay. And that's about it?
That's about it. Yeah.
And then something in the media. So what do you recall about details? Do you have any details?
No, I really don't watch the news because I mean I'm really busy all day with work, and I have 2 children, so I don't really bother to watch the news because it's basically negativity. So I don't really want to,
Welcome to my world. Do you believe everything you see
No.
or read in the media?
No.
Do you agree with me that they get it wrong sometimes?
Yes.
Okay, so number one, I told you, the number one concern we have here is your willingness to do what?
To hear both sides of
Well,
the
to follow the law,
to follow the law.
right? And don't get stuck in the two sides. It's my job to prove his guilt. I'm the only one who's got a burden here, okay? All right, so with the basic understanding that the media sometimes gets it wrong, the judge will tell you that your verdict cannot be based in any way, shape, or form on what you might have read, seen, learned, or heard about this case outside the courtroom.
Right.
Okay? Does that sound like a pretty good rule?
Yes.
Okay. And can you follow that rule?
Yes.
Okay, so regardless of what you may have Facebook or whatever, or seen in the media, can you assure us that your verdict in this case will be based only on what happens here in this courtroom if you're selected?
Yes.
Okay, great. Now, let's talk real quickly about the death penalty. You indicated on the questionnaire that you are a C. We call C. You don't know what that means. That means you think it's appropriate in some cases and inappropriate in other cases. Correct?
Yes.
Okay. The judge will tell you that the law is, and remember, I want you to do what?
Follow the law.
You got it. The judge will tell you that death penalty is appropriate in some cases and inappropriate in other cases, essentially. It's not. I'm paraphrasing, okay? Here's how it works. In the state of Florida, you can only be subject or face the death penalty if you commit a first-degree murder. okay? You cannot be subject to the death penalty for any other kind of murder, second degree, manslaughter, third degree, whatever, okay? Can you accept that?
Yes.
All right. But just because you're convicted of first degree murder doesn't mean you must get the death penalty. Do you understand that?
Yes.
But what the judge will tell you is, the first part of the trial, you decide, did we prove he did it? And if you determine that we proved he did it, we go to the second phase of the trial. And that's the phase where you have to decide what is the appropriate punishment. The two are separate, and it should not be confused with one another, okay?
Okay.
At the second phase, before you can vote for the death penalty, and are you capable of doing that in the appropriate circumstances?
Yes.
Okay. Before you can legally do it, we have to prove to you the existence of what we call an aggravating circumstance. One aggravator under the law is that the victim is less than 12 years old. That doesn't apply here, obviously, okay? So, if this were about a dead child, and we proved to you that the victim was under 12 years old, you could vote for death. You do not have to vote for death, but you could. And the only way you could is because we proved an aggravator, all right? Then, are you getting bored?
No, it's very
okay.
interesting now.
All right. Then, once we've proven the existence of an aggravator, you weigh it. Well, what does that mean? That means you consider it, and you say, does it make this first-degree murder something more than the run-of-the-mill first-degree, to the extent you can have such a thing, but more than the run-of-the-mill first-degree murder? Does it make it so aggravated that it warrants the imposition of the death penalty? And if you decide that it does, you can vote for death, but you don't have to vote for death, okay?
Okay.
The final step in the process, and there won't be a test at the end, the final step in the process is the mitigator. The defense can put on evidence of mitigation. It can be virtually anything. Background information. One mitigator in the statute is, doesn't apply in this case, but for purposes of our discussion, the victim was killed by an accomplice. Okay? So you got two people committed the crime of our theoretical baby killer.
Right.
But the baby was killed by somebody other than the defendant. And I'm paraphrasing, but that could be a mitigator. You could look at that and say, his role is so small in this, and the real bad guy is the guy who killed the baby, and I think that outweighs the fact that a child is dead. Are you with me? The law says you must vote for life. Are you okay with that?
Yes.
That's how it works. The judge will give you all of the instructions to follow, but that's essentially the death penalty process. Can you follow that if you're selected as a juror?
Yes, I can.
Okay. You follow the law?
Yes.
Thank you very much.
Mr. Manchin.
Hi. Is it Mr. Ronda?
Yes.
Did I say it right?
Yes, Mr. Amanda, yes.
Okay, good. Hi.
Hello.
I'm going to, if it's okay, I'm going to ask you some questions about the media exposure that you've had
Okay.
from this.
That's fine.
Okay. So let me just kind of start with the most recent point in time. Have you, ever since you guys came in here and filled out those questionnaires and the judge said, don't read any media reports about this, don't watch anything about it, somebody tries talking to you about it, don't listen to them, tell them that you can't talk about it. Have you had to walk away or from any situations like that?
No.
Okay. Any situations where you've overheard people talking about it and you just said, oh, I better not go over there?
No, I haven't really been exposed to anything, and I truly haven't spoken to anybody about it, so even my husband or anybody, but so no.
Okay, all right, well, you're following the rules. That's good. Okay, so let's back up. I was taking notes. You were telling Mr. Backetall that on Facebook is how you originally learned about it?
Yes. I think I was at work when it happened, and I saw one of my friends on Facebook post something about it, and I just read and couldn't believe that it happened here locally.
I heard that you said that there was photos posted. Was there articles posted as well, or what were you seeing?
Well, the photo that I remember that was posted was just the officer's photo, which just basically just him.
Okay.
Photo.
His face.
Yeah,
And,
that was it. Yeah. In
Okay.
uniform. So that's what I recall.
all right, and then you wound up clicking on the link and reading the articles as well?
I did the first time when I first saw it, and then after everybody, it's like once
something goes on Facebook, it's like a plague, everybody has to post about it.
Okay.
So the first time I did, and then the rest I didn't.
First time you clicked on it, or the first time you posted about
No,
it?
no, I never posted about it. I clicked on it to read it, and that was basically it.
Okay. And how did you feel when you saw that?
Well, I mean, I felt sad because I'm a very empathetic person. I kind of put myself in the position where his family might have would have been like in that position. And but then again, I don't know what happened, what really happened, and I couldn't really have an informed opinion on what really went down. So.
Did you wind up? I'm sorry, I didn't mean to cut you off.
No.
Did you wind up seeing stories and articles and I guess Facebook posts about Sgt Morales' family also?
No, not really. No.
How did you know they had a family?
Well, I just said I put myself in that position thinking if he would have had a family, how his family would have felt. If, say, for example, if that was my brother, how would I felt if, if something happened? I just couldn't believe that happened here locally in Fort Pierce where I live.
Okay. And I thought I remembered. Who, I might be imagining that you said that it was your husband, was it? But after you heard about this in the media, you wound up talking about it with who?
With my husband. I just told him when I came home that day and saw it on Facebook, and I'm like, I just couldn't believe that happened here locally. Like, you hear things on the news when I do watch the news, and it doesn't happen at home, and when something does happen near home, it's kind of hard to believe that kind of stuff happens out there.
Had your husband watched on the news also?
No, he didn't know.
Okay. Okay. All right. Now, other than the first day and the first week or so when this was happening, when it was just nonstop over your Facebook wall, and am I putting words in your mouth? Is that a fair assessment about what was going on? Everybody was posting about it, talking about it?
Yeah, it was in the media, yeah. It was basically when you go on Facebook and you see your social feed, yeah, basically you see that on there. But after this, like I said, the first time I clicked on the first article I read, I didn't really think, I didn't want to continue reading it because I knew, like, how I told him first, the news is basically negative stuff, and I really try to shy away from that from my two girls, that I don't really want to bring that in the home, so.
Okay. And you're gonna have to kind of forgive me because I'm only on Facebook to see pictures of like my little niece and nephew and some family members when they go on vacation, and I don't do the whole thing very much. So I know that when they post stuff or they say, oh, my cousin Hannah likes this, it pops up, and I don't even care, but there it is, and there's a picture of something. Do you have like hundreds or thousands of friends that you?
No, I would say like maybe 100, 200 friends total, but the people that have posted, I think I would say maybe 20 or 50 people.
And were they constantly?
It wasn't really a constant thing. It was basically like in the first days and the first week that we just saw that on the news feed. And like I said, the first time I clicked on it, and then the rest I didn't really read up on it or read up on the story, what was going on, or an investigation or anything like that. I didn't really read up on anything.
How about over the past couple of years?
No.
There's been. Have you? We talked a little bit about Sgt Morales' family. Did any of your friends or family share or like or whatever it's called on Facebook about the benefits that were going on for his family?
No, I didn't really see any of that. No.
Have your friends and family been exposing you to it by sharing these articles on Facebook throughout the past couple of years?
No, it's not recently, no, that was in the past years, like when I said when it recently happened, it was going around the social feed, but recently I haven't really seen anything, and then ever since I've come in here, I'm trying to stay away from the news and stuff like that, like how the judge access is.
Mm-hmm. How about the media exposure when you first got your jury summons? I'm guessing you got your jury summons when? A few weeks ago? 3-4 weeks ago?
Well, the first one was 2 months ago, and I had to keep on my schedule for work, but yes, it was for this one, yes, a few weeks ago.
And did, there's been, the pretrial publicity has been ramping up as we've been getting closer to trial here. Have you been exposed to any of that?
No, and honestly, I honestly thought this case was done with, and when I first came in and read the questionnaire last week, I was like, wow, it's not even over with, but no, I haven't been seeing anything about the trial or anything. Last week was my first knowing about it, which was me coming here.
Mm-hmm. And nobody was throwing stuff on Facebook?
No, I didn't, no.
And do you watch, how do you normally get your news?
I don't really watch.
Okay, no, that's fair. Do you read the newspaper, or do you read online?
I mean, I read online some articles, and then I do read what people post on Facebook and recent things, but recently I haven't seen anything pertaining to this case, so.
Okay, so I'm done asking you questions about media for right now, all right? But Ms. Celedonio is going to ask you some questions about about your feelings about the death penalty. Okay?
Okay.
So thank you very much for your time.
Thank you.
Hi, Sandra. How are you?
Good, how about you?
I just have a couple questions, because it seems as though you want to follow the law, and that you are open to listening to aggravating and mitigating circumstances and factors before you make any type of recommendation.
Yes, that's correct.
Okay, which is great. And the one thing, though, that kind of concerns me when somebody puts middle of the line, I believe the death penalty is appropriate in some cases and not appropriate in some cases. To me, that says, ask this girl a few more questions. Like, so what kind of cases do you think the death penalty would be appropriate to you?
Cases, like, just say, like, someone comes up in the middle, like, you're minding your own business, someone comes and just kills the person, and without any cause, or without any just cause, or without any, oh, that person was aggravating me, or anything like that. I would agree that would be because that's a life that person took away, and for not any good reason, not like a self-defense or anything like that. The other person didn't cause him any harm to the other person that did murder him. So I would believe in that case that the death penalty would be just cause for that. If someone, can I use, for example, this case, or how, what?
Do you have an opinion about this case?
Well, I don't really have an opinion, because like I said, I don't really know both sides of the story. I just heard that a cop was shot down and he was murdered. That's all basically I heard.
Okay.
But I didn't really hear anything. But
Okay.
Just say for a case that someone did murder a child or murdered someone, I do believe I have to listen to both sides to hear what was the reason. But if he didn't have any good reason, or it wasn't self-defense or anything like that, then yes, I do believe that the death penalty is for that.
Appropriate. Okay, so hypothetically speaking, on a hypothetical case where first-degree murder was decided by the jury, and now they're in the second phase, which Mr. Backell was explaining to you, that that's where the aggravators are proven beyond a reasonable doubt, if any, and the mitigators are presented by the defense, and you give the weight to what you think you believe that has been proven to you, what kind of information would you want if you were sitting there in the penalty phase of a case in which you had already decided guilt, okay? For a mitigator, what kind of things do you think that you would have, you would be considering in a worst case scenario case where hypothetically, you, like I said, you decided that premeditated murder happened. You're hypothetical where you're saying maybe somebody didn't have a self-defense theory, or it wasn't an accident. I don't know, some of the other examples you were giving killed a child. Hypothetically, you decided the guilt, but now you're sitting there and you're saying, okay, now we have two choices. We need to decide. You know, you individually have a role in the penalty phase to recommend life or death.
Right.
Those are the two options you're going to get if you get to that stage in the state of Florida. Okay. So what, in your mind, because I'm sure as you sit here, 3 weeks ago, 6 months ago, last week, well, last week we won't count because last week you came in and did the jury questionnaire, so you knew this was the case that you were going to be involved with. But, you know, 6 months ago, 6 weeks ago, how strong were your feelings about the death penalty?
Well, I don't really have strong feelings, I would say. I would have to listen to both parts to see if the person that did commit the murder had a bad background, or if they did possess a weapon, and what was their motive for killing the other person. So I think I can basically go both ways.
Okay.
So but I just have to listen to the evidence.
Okay. So you would want to know about the why.
Yeah.
Okay, because you used the word motive, so motive usually comes with why did it happen.
Yeah, what was the reason.
Okay. And when do you feel, because remember I told you, in the hypothetical case that we're talking about, you've already decided the person's guilty, premeditated murder.
Okay.
Which is the highest crime you can be charged, right?
Yeah.
You got the two choices. You just told me a few things that you would consider for mitigation.
Right.
Okay. When do you think a life sentence would be appropriate? Or do you think it's ever appropriate in a case where you decide premeditated murder? Because remember, there's no self-defense, or there's no mental health defense,
right,
as you would say.
Right.
There's no accident if you've decided it was premeditated murder. You've eliminated all those things.
Right.
Okay, because you wouldn't have found him guilty of premeditated murder, hypothetically, right?
Right.
Because you would have been given that defense, and you would have found him not guilty if you believed that that was proven to you. So you don't, none of those factors come into play.
Right.
Okay, because now you've got the two choices to make. So when do you think, even if it is premeditated, is there any circumstance in your mind that a life sentence would be the appropriate sentence?
I mean, either way, I mean, you can go that a life sentence is appropriate. I mean, if you want to make the person suffer and live with what they did for the rest of their life, or you can give them, I mean, like I said, I can go either way, but if it was premeditated and you knew what he was doing, yes, I agree for it to be a death penalty.
Okay, you think you would lean more towards
Yeah.
the death penalty at that point? Okay. So you're saying that the mitigators would have to be very significant mitigators for you,
Yeah, I would say.
if you found somebody guilty of first degree premeditated.
Right.
Okay.
I can know anything else.
Yes. Okay. You cannot vote for death unless there's an aggravator that you think is weighty enough to warrant the death penalty. Regardless of what the facts of the case might be, if you don't have a legal aggravator at law, you cannot vote for death. Can you accept that?
Yes.
Okay. If you find that aggravator and they put on mitigation, if you find that mitigation to weigh more than that aggravator, you must vote for life. It's as simple as that. That's the law. Can you follow the law?
Yes.
Okay, and again, they're asking, what might you think is an aggravator, or what might you think, the judge is gonna tell you what they are.
Right.
Okay? Can you promise us that whatever the judge says is the aggravators, and whatever the mitigators, and how you apply them, that you will follow the judge's instructions?
Yes.
Any question in your mind about that?
No?
Okay,
You're right there.
thank you.
Y'all wish to have her call, or do y'all want to approach?
I don't need to approach.
Miss Rhonda, I'm gonna let you go today. I'm gonna have you call, call this number here. I'm gonna give you on this card, Thursday after 5 p.m. to let you know whether to come back or not. Okay, so if you can call this number Thursday after 5 p.m. You don't need to come tomorrow.
Okay.
Okay?
Okay.
That make sense?
Yes.
Okay. As soon as she gives you the card, you can go. Thank you very much for bearing with us. Who would y'all like next?
Has Mr. Burek made his return, or no?
We're gonna check now. Did Derek return seat 11? No, he didn't, sir.
Okay, thank you. May we have Mr. Moulton in seat 14?
John Moulton, seat 14. Yes. Sir, right down here, please.
Bolton, thanks for bearing with us. You just have a seat right there where he's indicating.
Right here, please. Thank you.
You're not in trouble, you haven't done anything wrong, don't worry. They're just going to ask you some questions outside the presence of the other folks for just a few minutes. If you'll just make sure you speak up for us and just be as candid with us as you can, okay? Thanks for bearing with us.
Good afternoon, Mr. Moulton.
Good afternoon.
Okay, just the reason you were called in is to talk to you just kind of briefly about the death penalty. Have you ever served as a juror in a death penalty case before? No idea how it works?
No.
Well, guess what? There are rules that apply to how it works in this context, okay? And those rules are the law, and we're in a court of law, and the judge will tell you what those rules are. And all we're looking for is a commitment that regardless of what your personal opinions or feelings about the death penalty might be, that you will follow the law. Are you good with me?
Yes.
Okay. As we start off, is there any reason why you think because of your position or feelings about the death penalty that you would be unable to follow the judge's instructions on the law?
No.
Okay. Here's very quickly how it works. The defendant is charged with first-degree murder. If at the conclusion of there are two parts of the trial. The first part of the trial is, did he do it? If you as a juror determine beyond a reasonable doubt that the defendant committed first-degree murder, then we move to the second phase of the trial, which is the phase of the trial to consider what the appropriate punishment is, either life in prison without parole or the death penalty, okay?
Yes.
Okay. So, not all murders warrant the death penalty. Second-degree murder, you can't even get the death penalty. Manslaughter, you can't get the death penalty. The only case for which a death penalty is a potential is first-degree murder, all right? But even all first-degree murder cases are not necessarily death penalty cases. You got to have a number of things, okay? You've got to have what's called an aggravator. So the fact that it's premeditated murder doesn't necessarily mean death penalty. At the second phase of the trial, we're going to put on evidence of aggravators. An aggravator at law, for instance, would be the defendant, it doesn't apply here, the defendant killed a child under the age of 12, okay? And if the state proved beyond a reasonable doubt to you that the victim of this homicide was under the age of 12, you could vote for the death penalty, but you don't have to. Are you all right with that?
Yes.
That's the law. I'm just getting your commitment to follow. I know this is tedious. Now, if you believe we've proven beyond a reasonable doubt that the child is under age 12, you now weigh that aggravator. And you look at it and you say, is this aggravator so weighty so as to aggravate the charge of first-degree murder that, in my opinion, it now warrants the death penalty? Then, and only then, can you vote for death. Do you follow me?
Yes.
And can you follow the judge's instruction in that regard?
Yes.
Okay. Then the final step, sir, and I'm going to sit down. Mitigation. The defense has the ability to present mitigation to you. Those are things that would lessen the punishment. For instance, theoretically, hypothetically, one of the legal mitigators at law is that the victim was killed by somebody other than the defendant, but the defendant and that person committed the crime together, but the victim was killed by another person. Does that make sense?
Yes.
Okay. You could look at that and say, well, the fact that he was involved in the crime is bad, and it's a child, and that's bad, but he's not the one who actually did it. So the mitigation now outweighs the aggravation. And under those circumstances, the law tells you you must vote for life. Could you follow that instruction?
Yes.
That's how it works. Can you follow the judge's instructions on that death penalty scheme?
Yes.
Okay, I appreciate your patience and your attention. They may have some additional questions.
Hi, Mr. Molden.
Hi.
I just have just a few questions. You're on the questionnaire that you filled out a week ago. You said, I haven't seen any news or media reports about it. Do you remember?
Yes.
Do you remember okay.
One of the last questions.
Yes. Okay. So, my question to you now is, there's been a bunch of media about this case. So, in between when you filled out that form and today, have you been exposed to some media about this case that you had to say, I can't watch that?
Yes.
Or you have?
Yes.
Okay. Could you tell me a little bit about that?
Sure. Wednesday morning, I was listening to NPR on my way to work, and the beginning of an article came on the radio that announced that jury selection was beginning, and I turned my radio off.
Did they wind up discussing a little bit about the case?
I didn't hear the end of it. I heard enough of it to realize it was jury selection, and that it was St. Lucie County, so I turned it off.
Okay, so you followed Judge Vaughn's instructions about not listening to media then. Have you been exposed to any other media about the case?
No.
Anything else where people were talking and you talking about the case and you said, oh, I shouldn't be listening to that because I'm a potential juror?
No, I've heard no one discuss it.
Okay, all right, thank you very much. I don't have any other questions about the media. Ms. Celedonio is going to have some questions for you about your thoughts about the death penalty, okay?
Sure.
Okay, great, thank you.
Good afternoon, Ms. Mulder.
Hi.
Hi. I noticed on your questionnaire that you put you were right middle of the road, that you believe the death penalty is appropriate in some cases and not appropriate in other cases, right?
Yes, it's a serious decision with complex criteria, from what I've heard so far.
Yes, it definitely is. So with that being said, I want to know a little bit further about your personal opinions on that matter, okay? Can you tell me a little bit about the type of circumstances that you believe would warrant a death sentence?
I don't know what the law states, what the criteria are in Florida and so on.
Okay, well, let me give you a hypothetical, okay?
Sure.
Hypothetically speaking, we have a case. Somebody's charged with first-degree premeditated murder, okay? You're on a jury that decides the guilt of that person, right? Your jury duty is completed and you have found this person guilty of premeditated murder, right? There's two phases to a murder case in the state of Florida. The law says if you determine that this person is guilty of premeditated first-degree murder, you must go to a second phase, which we call the penalty phase.
Mm-hmm.
And that's why we have to talk about
Sure.
the penalty phase with you now, because we only have this opportunity, and some people are, a little bit thrown back by us talking about a penalty before the trial has even started. However, we need to do the old standard, the horse before the cart type thing, cart before the horse. Okay? So with our hypothetical situation, so now you're at the second stage of the phase of the trial, and you're at the penalty phase because you've already determined that this person is guilty of first-degree murder. Now, you were given the law, which means, which gives you two options at that point. One, you can find the person, you can sentence the person to life without the possibility of parole, and I'll change the hypothetical to tell you that you as a juror get to give a recommendation of one of two things. One, life without the possibility of parole, or two, you recommend the death penalty. Those are your only two options, okay? That's the law in the state of Florida if that's where the verdict ends up, okay? So on your hypothetical, I want to add another fact. You determine when the state gets up and presents aggravating factors there are what we call statutory aggravating factors. That means the law has listed a number of aggravating factors. If the state proves to you one of those statutorily listed aggravated factors, they prove to you beyond a reasonable doubt one of those, then you may recommend the death penalty for that person that you've already determined they were guilty of first-degree murder. Okay? You still with me with the hypothetical?
I'm with you, yes, on the hypothetical.
Okay.
You said may, and you said one aggravating factor. Are there other aggravating factors that weren't
Well,
proven?
there's a lot of aggravating factors, but the state has to stick to what we call statutory, which means they're in the law books.
So
Okay?
if one of those exists.
If one of those exists and they've proven it to you as a juror beyond a reasonable doubt, then you may choose the death penalty in your recommendation to the court for sentencing.
Okay, I understand now.
Now, if then on the other hand, what happens is the defense gets up and they present what we call mitigating factors. Some of those mitigating factors can be statutory, and some could be catch-all of anything. For instance, background, upbringing, mental health, anything that was going on in that person's life that the defense feels would warrant you considering to lean towards a life sentence versus the death penalty. Okay?
Yes.
So the burden of proof for the defense is not the same as the state. The state has to still prove beyond a reasonable doubt that aggravating factor. Okay? But the defense only has to prove by the greater weight of the evidence. In other words, they have to prove to you that more likely than not that mitigating circumstance is true. Okay? And what you do as a juror in the penalty phase is you decide individually what weight you're going to give the aggravator, the mitigators. But if you decide that the mitigators outweigh the aggravators, then you must choose a life sentence. Okay? Like in our hypothetical, the state presented one aggravator that you believe was proven beyond a reasonable doubt. That's all they needed to do. But the defense got up and they proved to you, I don't know, two mitigators that you thought weighed a lot, and that gave you the reason to say, you know, they overweigh the aggravator that was presented statutorily. The law says you must choose life. Whereas if the state proves the aggravator and the defense proves these two mitigators, and you say, you know, I'm not real sure if I give them much weight, you still don't have to choose death. You see how you only have to choose, you never have to choose death. You may choose death, but you must choose life if the mitigators outweigh. Does that make sense?
Yes, it does.
Okay, so you're given a lot of individual thought process, and your opinions really matter in that recommendation. And the court is going to take great weight in that, in our hypothetical case, that the court takes great weight in your recommendation. So it's important for us to know where you are as far as what kind of things you think that you would want to hear in making your decision in the hypothetical hypothetical case. Can you think of anything that you would want to be presented with?
Past law related to the mitigating factors, you know, what you might consider to be a mitigating factor, the law might not. In the same way, what I consider to be a mitigating factor might not be considered mitigating under the law.
Okay.
You know, to me, from what little I've learned in the last 5 minutes, it seems to be a weighing of facts with different levels of proof. One beyond reasonable doubt, one a preponderance of the evidence or a beginning of the evidence, enough to raise a question.
Right.
And you know, I have to look to see what truly is law and what truly isn't law, and then rely on the guidance of the judge to explain that.
Okay, in our hypothetical case, your recommendation, it's going to be an individual recommendation, okay? And can you think of any circumstances where something was so evil in your mind that the only appropriate sentence to you would be a death
Well, once again, I don't know exactly what the law states on the requirements for it. Hypothetically, I can think of some mitigating factors that might be enough to prevent it or to preclude it and demand life in prison.
Okay.
Like defending somebody else, committing, I don't even know if that's a murder, if you're defending somebody else.
Well, actually, it's not. If you're defending somebody else, premeditated murder would have excluded that if you found them guilty in the hypothetical case. I mean, as far as your thought process, it seems to me that you're a very analytical person. Is that true?
My education is a biologist and an engineer, so yeah.
Okay, okay, well, we can appreciate that. So when you say you're middle of the road, are you saying that you basically listen to everything that's presented to you before you lean one way or the other?
Yes.
That's good. Thank you very much.
Jill, just want me to have him call, or Jill will approach on him? Thank you, Mr. Bolton. I'm going to give you a card here with a number on it. If I can have you call it tomorrow, Thursday, after 5 p.m. There'll be some direction on there whether you need to come back or not, and if so, when. So if you'll call it Thursday after 5 p.m., you don't need to come back tomorrow.
Okay.
Or Thursday, but call Thursday after 5 p.m.
Okay, can I go over to the other courtroom now?
Oh, you can go.
Free for that?
You can go home or go back to work. You're free today, but just call, and you're free tomorrow. As far as we're concerned, call Thursday after 5 p.m.
Okay, great.
Thanks for bearing with us, sir.
Thank you. Have a good day, sir.
Who would y'all like next?
May we have Ms. Masterson, please?
Yes, sir. Bobby Barbara Masterson, Barbara Masterson, C-15.
Thank you.
Oh.
Ma'am, up here, please.
Masterson, thanks for bearing with us. Let me just have you come right up there on that front row.
Come right up here.
Anyone?
And take a seat right there, please.
Right there.
Thank you very much.
Thank you.
Thanks, ma'am, for bearing with us. You're not in trouble. You haven't done anything wrong. They just want to talk to you outside the presence of the other folks for just a few minutes. If you'll just make sure you speak up for us and be as candid with us as you can, okay? Thanks for bearing with us.
Good afternoon.
Hello.
Okay, so obviously we brought you in because first of all, this morning you raised your hand and said there could be something about the nature of the case that could affect your ability to be fair and impartial. And you also indicated in your questionnaire that you had some knowledge about the case and as a result of that knowledge formed an opinion and it says, quote, guilty, okay? And guess what? You're not off the hook yet. Okay. So here's what the law is, just quickly. And I just need to get your impressions and the judge needs to know your feelings about this. There's nothing wrong with reading about a case in the newspaper. In fact, that's exactly the kind of jury I want who's interested and involved in their community. It would be foolhardy to read the newspaper or watch the TV and not form opinions based upon what you read, saw, or heard. Okay? And again, that's just very natural. The issue becomes, can you set aside what you read, saw, or heard on the outside of this courtroom and set aside your opinion that you developed on the outside of this courtroom and render a verdict in this matter that is based solely and exclusively on the evidence and testimony offered here in court. So obviously, would you agree with me that the media doesn't always get it right?
True.
Okay. So if the law is you cannot consider anything you saw outside this courtroom in rendering a verdict, do you think that would be a good law?
Yeah.
So I ask you, that is the law, can you follow that law?
Yeah.
You can? Okay.
Go ahead. Yeah.
Well, yeah, if you're selected as a juror, you have to.
Exactly.
You've taken an oath to follow the law. Also, the judge will tell you, again, that the first rule of law is that the defendant, as he sits here today, you must presume him to be innocent. Now, that doesn't mean he's innocent, but what it means is you must come to this process, setting aside any opinions you have, any evidence you have from outside the courtroom, and assume as he sits here today, he is innocent. Can you do that?
I'm not sure I can.
Okay. You have a doubt in your mind about your
Yeah.
Okay. That's what we're looking for. And there's probably nothing I could say to you that would resolve that doubt in your mind, right?
Pretty close, yes.
Okay, all right, thank you. I don't have any further questions.
Thank you.
Then switch to Clark.
No objection, Judge.
Ms. Masterson, I'm going to go ahead and release you from service. I know it's been a long day for you, and I appreciate you bearing with us just a little bit. But you're free to go. You don't have to stay or come back tomorrow unless you want to. We'd love to have you stay, but you're free to go, okay?
Thank you.
Thank you, ma'am, very much for bearing with us.
Thank you.
Thank you. Please have Mr. Patrick in seat 16, or Johnson.
Yes, sir.
That's just release. Chief of calls.
Shoot 16. Sir, he just went to the restroom.
Can I go to the restroom?
Call the next, who else do you all wish to call after Mr. Johnson?
May we please have Mr. Presti in seat 17?
Yes, sir. Frank Presti, seat 17. Sir, up here, please.
Presti, thanks for bearing with us. You can just have a seat right there where he's showing us.